just want to draw everyone's attention to the International Network for Hate Studies. The aim of this network is to bring researchers together with policymakers, practitioners and activists working within the field of hate crime and hate speech. So this resource might be useful for you. If you just type in International Hate Studies into Google, or there's the URL there, the different resources that you might find helpful. We have a blog where we present new research and new ideas every month. The Anti-Hate Initiatives tab provides links to a number of different organisations who run initiatives and projects which address different aspects of hate crime. Here we've got prevention, reporting, responses, supporting victims, cyber hate initiatives. If you click on any of those, we'll list a number of different organisations and projects that are currently running, which you might find helpful in your own work. If your organisation or your project's not on there, then please email me. You can email me via the website just by clicking on Contact Us, or just type in Mark Walters Sussex in Google and my email address will come up. And we also have a number of videos as well addressing different aspects of hate crime. So again, if you have a new video that you want to send to us, then I will add it to our resources tab there under videos. And then very finally, the online library. If you want to find some research on a particular process or practice that you are implementing through your work, or you want to find some evidence to support something, you can always come to our online library where we hold thousands and thousands of documents of research relating to hate crime and hate speech. You can either type in a keyword, or we have a whole list of topics. For example, if you were to click on anti-Semitic hate crime, you'll get a list of all of the different pieces of research that we could find through different libraries and resources and online databases. And if you click on the link, it will take you to the full text. Sometimes that'll be free access, sometimes you'll have to pay for it. Okay, and then very, very finally, if you want to receive our newsletter, which we send out every month, which contains all of the most recent publications, all of the most recent events that are going on, yours would have been advertised, of course, and other conferences, blogs, just go onto the homepage and put in your details, and you'll be added automatically to our monthly newsletter. Okay, so free access. It's not funded, this either, so it's all in your spare time, all in my spare time. But please do use it. It's there for us as a collective, researchers and policymakers and practitioners, to come together so that we can be more effective at addressing and dealing with the impacts and causes of hate crime and hate speech. Okay? Good, good. So that's not coming out of my 15 minutes, all right? I was being cheeky. So thank you, Mark, for inviting me today. Mark has asked me to talk about what I refer to as the justice gap for hate crime. And the justice gap for hate crime comes out of a 2-year research study that we carried out at the University of Sussex on the application of hate crime laws in England and Wales. And I'll go through in just a moment what I mean by the justice gap, but it helps to inform us where we might want to go in terms of reforming the law in England and Wales. And this is particularly important because the Law Commission will be launching officially its consultation on hate crime legislation very, very soon. So from this, hopefully, we'll have some questions, and maybe we'll start to head towards some answers as to how we might want to reform the law in this area, so we are a country that more effectively addresses and challenges hate, at least within the criminal justice sense. So very briefly then, to start with, a reminder of what the legislation is in this area. I expect most of you know what the legislation is. Basically, there are 2 pieces of legislation when we're looking at hate crime. I'm leaving hate speech to the side for a moment. The first are what we call aggravated criminal offences. These are substantive criminal offences which are on the statute book. These are crimes under the Crime and Disorder Act, sections 28 to 32, covering racial and religious hostility, and a selection of offences only. So assaults, criminal damage, some public order offences, and harassment and stalking. So the only two characteristics that are protected in the criminal law, race and religion. The other piece of legislation that we need to be aware of is the Criminal Justice Act 2003, sections 145 and 146. These are sentencing provisions. They do not create specific criminal offences. What they do allow is the judge to enhance a penalty at the sentencing stage of the criminal process. That legislation covers 5 characteristics: race and religion, but also sexual orientation, transgender identity, and disability. So those are your 5 protected characteristics, and we have a dual system of hate crime legislation. Now, within our study of the application of those laws, we started by looking at the statistics on how many hate crimes there are in society, estimated, how many are reported to the police, and then how many go through the criminal justice process all the way through to what we call a declared sentencing uplift. That's when we know that hate crime legislation has been implemented. Okay? Not just conviction, but conviction and then the judge declaring that there has been an uplift, and that shows to us that hate crime laws have been applied. Now, the gap between the number that's reported to the police and the number that result in conviction and a declared uplift is referred to as the justice gap. Okay? Now, there are many, many reasons for the justice gap. To do with victims withdrawing statements. It could be policing issues, evidential issues. There are a whole variety of reasons why there is a justice gap. What we looked at in this study were some of the legal reasons, some of the reasons which relate to the application of law in practice. And I'll go through some of those issues in just a moment. But this is what the data looks like for hate crime. This has been updated since we did the study, so this is the most recent statistics that we have. We know in 2017 to 2018 there were an estimated 184,000 hate crimes in England and Wales. It's a cautious estimate based on data from the Crime Survey for England and Wales, a victimisation survey. They estimated that 97,000 hate crimes were reported to the police, and the police then recorded 94,000 hate crimes. So the difference being, of course, victims reporting a hate crime to the police and then the number that are recorded by the police flagged as hate crimes. This number has in the past been much, much bigger. So it looks here like the police have massively improved their recording practices in terms of people reporting crimes to the police. So that's good. Normally that should be many, many more thousands, but here it's only a few thousand. Then we go down to prosecution. So out of the 94,000 recorded, we have 14,000 completed prosecutions by the CPS, resulting in just under 12,000 convictions. However, only 7,700 of those convictions resulted in a declared uplift. So we go from 97,000 hate crimes reported down to 7,700 where hate crime legislation is successfully applied. That's a justice gap of 92%, i.e. 92% of cases do not result in hate crime legislation being applied in practice. So 8% of cases. If we look at the actual estimated number of hate crimes, of course, that percentage shrinks further. It's particularly bad for different types of hate crime. And in particular, we found that disability hate crime, there is a huge gap. So here we don't have estimated numbers for reported, but we do have numbers for recorded, 7,226 for that period, resulting in here, I'm not sure if you can see, but 133 cases with declared uplifts. So that's a justice gap of 98.2%, or 1.8% of reported or recorded cases here. The reported would be higher. Recorded cases result in the application of hate crime legislation. If we were to look at the actual estimated number of hate crimes that are disableist in nature, we're looking at 0.2% of disability hate crimes resulting in the application of hate crime legislation. So a problem for the law, a problem for law enforcers and prosecutors and judges to look at. Now, I keep doing this, it's not working. Now there are many issues facing the criminal justice process. I'm not going to go through all of them because we'll be here for a few hours and you all fall asleep. I'm just going to highlight two main issues that I want us to focus on today. The first is that the law creates a hierarchy of hate by having a lack of parity across the hate crime strands. So different hate crimes are treated differently in law. Why is this problematic? Well, substantive criminal offences, those are the aggravated criminal offences, racially and religiously aggravated crimes, are treated differently to the other crimes where there is no aggravation in law. And what we found was that there was widespread lack of awareness, not in this room, but across the general criminal justice system, of sections 145 and 146, and they were being applied very inconsistently, sometimes not applied at all. Thank you. There's also, therefore, different sentencing powers for offences that fall under the criminal law, that's the Crime and Disorder Act, compared with those that fall within the domain of the Criminal Justice Act. I'll give you an example. Racially aggravated assault. What's the maximum sentence? Where are police officers? Put you on the spot now. Quick.
We just enforce it, we don't know.
Oh no, this is just the teacher coming at me now. I'm very disappointed you've not done your homework.
For which one?
Racially aggravated assault, common assault.
For a common assault?
Yeah.
2 years.
2 years, yes, well done. You get the gold star. Well done. Leicestershire, streaming ahead.
Leicestershire, but he's parked in Met police station.
Oh, okay. Everyone just calm down. Let's not get heated. Okay, so a sexual orientation aggravated common assault would have a maximum sentence of
6 months.
6 months. Oh, getting in there quickly. Well done. So, yeah, a huge disparity between the sentencing maxima for aggravated offences compared with hate crime offences which fall within the sentencing legislation only, creating what many of us now refer to as the hierarchy of hate. Now, an area of particular interest to us all really is disability hate crime offences, not necessarily more than the other types of hate crime, because obviously everything's important and it all goes within one framework of law, but here we have questions around whether the way in which the law is actually prescribed, the wording that's used, is it fit for purpose for different types of hate crime? And in particular, disability hate crime is a problem. It's a problem for lots of different types of hate crime, but this is where we focused our attention. And in particular, this word hostility. Now, we had presenters earlier from Scotland. They don't use the word disability, they use the word malice and ill will, which, under a recent review by Lord Bracadell, said that's archaic. We need to change that legislation so it replicates the English law of hostility. No, 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 no. Hostility works for many types of hate crime, but it doesn't work very well for disability-related offences. Why? Because as the statistics show us, a high proportion of disability hate crimes involve crimes where there is no clear demonstration of hostility in the literal sense. 38% of prosecuted disability hate crimes are sexual or property related, and they often are linked to what we call perceived vulnerability, perceived being important there. So people perceived to be weak, less human, less worthwhile, targeted with quite serious, sometimes, forms of violence, degrading forms of conduct. When they go to court, very, very regularly, the courts will say this isn't about hostility. Hostility is where you shout something at someone and you use racist language or homophobic language. What this is about is vulnerability, and I'll deal with that separately at sentencing. What that does is it says all of these types of hate crimes aren't hate crimes. They're about vulnerability, about protecting victims with disabilities, and again, that perpetuates this cycle of infantilizing disabled people, treating them differently with a form of bias. So we need to think about how the law might be changed in order to more effectively respond, particularly to disability hate crime. So some questions for the workshop, and this links into the Law Commission consultation because these are the questions they're asking. How do we ensure parity? It's not okay just to say, well, we want the other 3 characteristics to be put into all of the legislation. What kind of legislation do we want? What's going to work most effectively? Do we want substantive offences? That's aggravated offences. Do we just want to rely on sentencing provisions? Quite often the evidence falls out, it drops out of the system. Or what I refer to as a hybrid system, a new hate crime act, and I can explain what I mean by that system. I don't have time to go into it because it's very technical, but what I mean by that I can talk to in the workshop in just a moment. And do we need a new legal test? Is motivation of hostility within the current legal framework fit for purpose? Or should we be thinking about a different legal test? And we refer to this legal test as the by reason test. Is someone selected not because of hostility, but by reason of their identity characteristic? If you are selected by reason of your disability, should that be a hate crime? We need to think about that a little more carefully. And finally, who should be protected? It's not, I don't think, sufficient for us to just say, let's just include this characteristic, that characteristic, let's use the Equality Act. This is the criminal law. If we to use substantive offences in the criminal law, then we need to think about criteria that's clear and coherent to protect the concept of hate crime, to protect its potency within the legal framework, and to make sure that it still functions to address the causes and consequences of different forms of hate crime in our society. And I'll finish there. Thank you.